Good morning to all of you. Today we are going to discuss the topic malicious prosecution. You all know what is a prosecution. So it is the duty of the state to conduct prosecution in all criminal offences, right? So in civil cases, the burden of proof or prosecution lies on the plaintiff or the defendant, whoever he may be. But anyway, to prosecute means to process a particular thing till its logical conclusion. Suppose if you file a case, you must attend the court, you must produce the witnesses, you must submit the arguments and take it to the logical end. That is what is called prosecution. But this prosecution is if it is done in a malicious way. What is malicious way? So M-A-L-I-C-E, malice. So malice means a bad intention. Maliciously, that means the intention to see that others suffer without any probable cause. So your intention is, when your intention is to see that the others suffer for no reason, then it is called malicious. So malicious prosecution, that is intentional suffering by filing false cases. So definitely you can go for tort. Because you are injured, there will be definitely terrific mental agony, even though there is no physical harm. Financially and mentally you will be suffering a lot, and you can file a case of tort in such malicious prosecutions, right? It is an intentional tort, and it is an abuse of the so-called legal procedure. So please remember here, some civil suit or some suit should be instituted against the plaintiff. First of all, a suit should be instituted against you, and the suit must be disposed of, and it must be favoring you. So the person who filed the plaint, definitely he will suffer, the defendant will come out successful, and there should be some opinion of the judge that this case has been falsely planted or dismissed in favor of you, that means victim. Right? Please remember, these are the essentials of a malicious prosecution. Right? So without any reasonable cause or without any probable cause, if the suit is instituted maliciously or to gain some undue advantage, so such things definitely, when you sustain some damages, you can file a case of malicious prosecution. Now we'll go to the case laws. Number one, very famous case law, Gaya Prasad versus Bhagat Singh, 1908. Mr. Bhagat Singh, he filed a case against Gaya Prasad before the police. Actually, it's a false case. Of course, he has submitted so many false evidence, so many false documents, so many false witnesses or stock witnesses have come and deposited before police. So therefore, the police have believed their version, and they arrested the said Gaya Prasad, and also sent him to court. They filed the charge sheet against him. But during the time of the trial, the judge has opined that this case has been concocted by Mr. Bhagat Singh and acquitted Mr. Gaya Prasad. After acquittal, after taking the judgment copy, now Gaya Prasad filed a case against Bhagat Singh for the damages under tort law. Yes, the court has clearly stated that it is a case of malicious prosecution and awarded compensation to be paid to Gaya Prasad as against the case filed by Bhagat Singh. Actually, the Bhagat Singh filed the case, he was not successful. Now, Gaya Prasad was able to prove that the case was foisted intentionally, maliciously against him. Therefore, he is awarded compensation. This is a good example. Second, Abroth, you can call him as Dr. Abroth. Abroth versus North Eastern Railway Company, 1886. Those were also, because such incidents are occurring even now. This incident took place in 1886. Such incidents do take place nowadays also. Right? Actually, an accident occurred in this North-Eastern Railway, that means Assam area, Bihar, Assam, North-Eastern Railway, some railway accident took place, and so many people received injuries and so many people died. Right? One person posing himself as though he received so many serious injuries, he has gone to the Railway Claims Tribunal for the so-called compensation. Yes, he was granted. But later, the railways came to know that it is a false claim, and that means he has created some artificial injuries and he has gone undue claim. So they have appointed detectives in this connection. The detectives went further and came to know that this person consulted one Dr. Abroth, So this Dr. Broth created artificial injuries and has given the certificate as though that person has received so many injuries, even though in fact he did not receive any injury, he did not travel in the train. So since it's a false case, railway people filed a case of cheating against Dr. Broth and that person others. Of course, the case ended in acquittal. The case ended in acquittal, that's all. So because the railway people could not prove the case beyond all reasonable doubt or could not fix the accused to the crime. There may be so many reasons, there may be so many contradictions, evidence, somehow they were not successful. Now, Dr. Ebroth filed a case of malicious prosecution against Northeastern Railway, saying that he was a qualified doctor, he did his job perfectly, but they have unnecessarily lugged him in the case and they have maliciously tried to prosecute him, therefore he has suffered so much of damage, all these things are fine. But the court did not agree because the House of Lords held that the defendant has taken reasonable care because they have appointed the detectives. So to reveal the truth, facts, and honestly believed that Dr. Ebroth definitely he was liable for giving the false certificate. Therefore, compensation not granted. This is a negative example. Now two other cases. Abdul Mazid versus Harbans Chaube, 1974. Right here, Abdul Mazid was prosecuted under section 412 of the IPC, that is committing theft of or being in possession of the property belonging to a dead person or deceased person. Right, 412 IPC, he was charged. Actually, it's a dacoity case. He was being in possession of some hansuri or some gold ornament. Okay, right, the police came, raided him, they prepared the mazar, they charged him under 412 IPC and sent him to the court. But in the trial, during the trial, the court opined that the police have concocted this case and they have concocted, and since they have conspired with Harbans Chowde and they have foisted this case against the so-called accused or our victim Abdul Mazid. So after coming out, after the acquittal, he filed a case against Harbans Chowde and also the police, and he was successful. The court held the police and Harbans Chowde guilty and therefore they are liable to pay compensation. Very good case. Last case is relating to an advocate. Sachakam versus Dallu, 1983. So actually Dallu engaged our Sachakam advocate as a lawyer in a civil case against other persons. So the other persons are also known to Sachakam. So they engaged him as an advocate in another case in another court. But they were coming to Sachakam and they were speaking to him, and Dallu got a doubt that he colluded with them and he will not, Sachakam will not do justice to the case. So aggrieved by his attitude, she filed a petition before the Bar Council. So the Bar Council inquired the matter and came to know that both the cases are not in one court and that too, both of them are not case and counter. Therefore, yes, as an advocate he can practice. So the allegations are not proved. So held allegations are not proved. Now, Sachakam filed a case against Dallu, stating that she has unnecessarily initiated the so-called malicious prosecution or vilification or calumny against him before the Bar Council. But the court stated that she has got reason. The plaintiff, that is Dallu, she has got a reason because sufficient and reasonable case, because she has got a doubt. That's why in professional ethics we'll be telling you. So even though you do the cases of others, you should not appear doing like that. So normally we tell you, don't take up cases where your parties are there. So if you take up a case of one person, don't take up the opposite case because there may be doubt. Even your junior also, don't allow juniors to take up the other party's cases because you will be creating an impression in mind of the party that you are not going to do justice to them. This is what happened. Therefore, not liable to pay compensation. Friends, these are the 4 important case laws relating to malicious prosecution. So please read them thoroughly and enrich your knowledge, live your knowledge. Thank you very much.